Good afternoon to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This time we are going to discuss case law on the compassionate appointments. The Honorable High Court of Madras, Single Judge S.M. Subramaniam of Madurai Bench held that the compassionate appointment is only a concession, but it is not a right. But it is not a right. Please remember, it is only to mitigate the circumstances or to give a lending hand or a helping hand to the family of the deceased person who died suddenly while undergoing the job, while in service. So it is only a concession, but it is not a right. So this is what is held by the Honorable High Court of Madras. So actually, when we go to the case law, this relates to actually the husband of M. Suguna. She is the applicant. Actually, she is the applicant, right? So the husband of M. Suguna, he died in the year 2015 while working as a field assistant in the Land Survey Department in Theni district of Tamil Nadu. So the family was helpless. Ultimately, there was a minor girl to her. So therefore, she filed an application for getting a job to the daughter. In 2015, she filed an application. But the authorities, they rejected, stating that she is a minor, she cannot get the job because you can't give a job to a woman below 18 years of age. So therefore, on that grounds, it was not allowed and this girl was not provided with any job. Fine. By 2019, after 4 years, she obtained majority. Now she has become a major. She is ready to apply for the job. And therefore, Suguna filed an application through her daughter for a job on compassionate grounds. Once again, it was rejected. Now the authorities said that the application for the compassionate appointment should be filed within 3 years. So it is already 3 years, 4th year you have filed. So the limitation period is over. So once the limitation period is over, we can't help. That's why we tell you in legal aspects, vigilantibus, stantibus. Law will come to the help of the people who are awake, who are not sober, who are not sleeping. So this is the problem. So therefore, now once again it was rejected. So therefore, she has filed a writ petition regarding the same. When she applied, she was a minor. Now when she applied, the statutory period of limitation is gone. So she was not given any job. Her daughter was not given any job. Therefore, she approached the High Court. Here, Judge observed that, please remember, equal opportunity in the public employment, yes, definitely, it's a constitutional right, directive principles of the state policy, Article 39, all these things that they discuss that definitely they have to be provided equal opportunity. For that, the recruitment process, the age limits, the education qualification limits, so many things will be put. And the recruitment process will be done according to within the framework of legal framework of the Constitution. But here, what about the concession appointment? What about the compassionate appointment? When a person dies, then his son or daughter will be accommodated in any vacant post. So therefore, no training, then no physical requirement, and no all these things. They don't put up all these rigors like age, qualification, all these things. Minimum qualification is sufficient. So it's only a concession. It's not a bounty. So the government just said that all the appointments must be made within the constitutional framework for the regular appointments. But as far as the compensation appointment are concerned, no selection process is there. Then merely basing on the death, so they are giving the so-called post to mitigate the woes or problems of the deceased family. So please remember, compassionate appointment has to be literally restricted in the interest of the efficient public administration. Anyway, so rules are there. So if the girl is not Major at the particular time, yes, not allowed. When the period of limitation is gone, we can't help. So therefore, the High Court also stated that compassionate appointment is only a concession but not a right. You cannot claim it as a right. Of course, if the authorities say okay, no problem from the court. But if the authorities do not say anything, court also cannot interfere. That is the important point in this aspect. So please read the judgment M. Suguna versus state of so-called Tamil Nadu, and definitely you will be enriched with the legal knowledge, particularly regarding filing of application for the appointment of on compassionate grounds. Right? Thank you very much.